Can be. Dr. Resnick testified that Lindsay did not believe that she had the ability to resist that command. In his opinion, her mental illness left her unable to conform her conduct to the requirements of the law. Oh, read that again. Ready? Unable to conform her conduct to the requirements of the law. Boy, that sounds a lot like criminal.
The phrase was precise, too precise. Unable to conform her conduct to the requirements of the law. Those are not medical words. They are not diagnostic words. They are the exact language of a legal statute, and they came out of the mouth of a hired expert on a witness stand. That single moment changed the temperature of the room.
There?
Yeah, and by the way, that's totally improper for a psychiatrist to do that. They do not, a psychiatrist or a psychologist or a defense expert should never, ever be instructing the jurors regarding legal issues. And the prosecution, if I was in the prosecution on that case, I would have been down his friggin' throat. And I mean,
they weren't.
A lot of people would have been. And you can't do that. You can't do it.
Picture a signature at the bottom of a page still wet while the argument above it was already collapsing. That is what this testimony looked like. A forensic psychiatrist, brought in to explain a diagnosis, reached past his own lane and started instructing a jury on the legal standard they were supposed to apply. The problem is not that he had an opinion. The problem is that he dressed that opinion in the exact language of the law.
California, you can't do it. You can't do it in Massachusetts. And look, he also, another thing about his testimony, Ashley, and I don't mean to interrupt you, but he said she had no idea what she was doing at all. And it's like, really, dude? Yeah, and you don't have to do that. The law doesn't require that. She can know that what she's doing is wrong in Massachusetts, but
former homicide prosecutor Matt Murphy said it without hesitation. That testimony was totally improper. A psychiatrist or psychologist is never supposed to instruct jurors on legal issues. They can describe a condition. They can explain a diagnosis. They cannot lean into the jury box and hand them the statute. But that is precisely what happened.
No, the defense, look, on that one, from my view, my opinion, Reddington got away with murder on that. Sorry, excuse the pun. Like, having an expert instruct the jury as to law, again, totally improper to do that, guy.
And the prosecution did not stop it. No objection, no interruption, no pushback. Murphy did not hide his frustration. He said if he had been sitting in that chair, he would have been down the witness's throat. Instead, the words just hung there, clean and unchallenged. The paperwork already knew.
Dr. Resnick didn't believe that Lindsay knew right from wrong or could conform her conduct to the requirements of the law. He just didn't. And he was real clear about it. Too clear.
The defense expert was clear. Too clear. He said Lindsay Clancy did not know right from wrong. He said she could not obey the law. He said it so directly that it stopped sounding like a medical conclusion and started sounding like a closing argument delivered from the witness box.
I don't mean to interrupt you, but he said she had no idea what she was doing at all. And it's like, really, dude? Yeah, and you don't have to do that. The law doesn't require that. She can know that what she's doing is wrong in Massachusetts, but the question is whether she could conform her conduct to comply with the law.
Murphy identified the core problem immediately. The doctor did not need to go that far. Under Massachusetts law, the question was never whether she completely lost all understanding. The question was narrower. Could she conform her conduct to what the law required? That was the crux. And the expert answered it as if he were the judge.
A psychiatrist leaning over and telling the jury in legal language,
like almost code, right? He knows coding, legal procedure and code.
There are judges in Orange County, Ashley, and in LA that I've appeared in front of that would have been friggin' ripping that guy in front of the jury.
This is where the language matters most. A psychiatrist leaned over and told the jury, in legal code, what their verdict should be. Murphy has stood in front of judges who would have torn that witness apart in open court. He said some judges would have been ripping him right there in front of the jury. That did not happen here. The moment passed. The damage was done.
For Resnick, he diagnosed Lindsay with some very important things, and you need to know what these are because they all count when it comes to what the jury has to decide. He said Lindsay had bipolar 2 disorder with severe depression.
To understand why this matters, you have to understand what the two sides were actually fighting over. The defense expert diagnosed Lindsay Clancy with bipolar 2 disorder and severe depression. He said she experienced a postpartum onset of psychosis. He said she was frankly psychotic when she killed her 3 children.
He testified that Lindsay experienced what's known as a command hallucination. That's a voice directing her to commit a certain act. But according to Dr. Resnick, this was not simply a voice that Lindsay could hear and then choose to ignore. He believes that she was also experiencing a delusion of influence. And that means Lindsay, in his opinion, believed that an outside force had taken control of her body.
He described a command hallucination, a voice directing her to act, but not just any voice, a delusion of influence. She believed an outside force had taken control of her body. He described her as feeling like a puppet, something else pulling the strings.
And in his opinion, her mental illness left her unable to conform her conduct to the requirements of the law. Oh, read that again. Ready? Unable to conform her conduct to the requirements of the law. Boy, that sounds a lot like criminal.
Then he crossed the line. He translated that clinical picture directly into statutory language. Her mental illness left her unable to conform her conduct to the requirements of the law. That is not a diagnosis. That is a jury instruction. And it was delivered by the wrong person.
You're not supposed to do that. And look, there's a lot of emotions swirling around this case. This is real. It's horribly tragic. You get 3 little children that are dead here, and the process should proceed to the right place without anybody pushing the limits of what's fair.
Murphy did not mince words. This is a tragic case. 3 children are dead. The process should move forward without anyone pushing the limits of what is fair. And in his view, that testimony was unfair. It was improper, and no one stopped it.
Dr. Resnick. And they used his own published statement to do it. A statement that command auditory hallucinations can be easy to fake. Yeah, command auditory hallucinations can be faked, fabricated.
The prosecution did have ammunition. The defense expert's own published writings said command auditory hallucinations can be easy to fake. They can be fabricated. The prosecution brought that up. They showed the jury the doctor's own warning signs, claiming to obey every command, making no effort to resist. Those are red flags he himself had identified.
Multiple psychiatric hospitalizations and made previous suicide attempts connected to those symptoms. And the Commonwealth of Massachusetts pointed out that Lindsay Clancy did not have comparable documented history of voices, had no previous hospitalizations for psychosis. Yes, she committed herself and went in and said, I think I'm a danger to myself.
They contrasted her history with Andrea Yates. Yates had years of documented voices, multiple hospitalizations, previous suicide attempts tied to her symptoms. Lindsay Clancy had no comparable documented history, no prior hospitalizations for psychosis, no prior suicide attempts linked to hallucination.
The expert who took the stand for the defense, for Lindsay Clancy, to help her in her case, Dr. Resnick, has written that the unusually rapid disappearance of psychotic symptoms, that could be a warning sign too when evaluating whether someone's symptoms are genuine or phony baloney. So hold it. The prosecution is able to get in cross-examination of the defense's own medical witness who says she was in psychosis. They were able to point out, well, right after the killings, that psychosis really sailed. It was gonzo. And you yourself, doctor, have said if those symptoms go fast, it could be a red flag that it was phony. And according to records discussed in court, Lindsay Clancy has denied experiencing any hallucinations before.
Then they pointed to the aftermath, the unusually rapid disappearance of psychotic symptoms. That was another warning sign in the doctor's own work. After the killings, treatment records described her as clinically stable, engaged, showing no observable symptoms of psychosis. The defense's own expert had written that fast, disappearing symptoms could be a red flag. The prosecution used his words against him.
Psychiatrist Dr. Avram Mack, who told the jury that he does not believe Lindsay was psychotic at all. Dr. Mack agreed that Lindsay suffered from major depression and anxiety. Postpartum, sure, but he said he found no evidence that she was experiencing mania, hypomania, or psychosis when she decided to strangle her kids hand to hand, right, using exercise bands. Dr. Mack also focused on the sequence of the killings of those kids, describing Lindsay as carrying out an organized one-by-one effort to accomplish a particular goal, a very sinister goal. He also pointed to discrepancies between what Lindsay.
The prosecution's own psychiatrist said he found no evidence of mania, hypomania, or psychosis. He described the killings as an organized, one-by-one effort to accomplish a particular goal, a very sinister goal. He pointed to discrepancies in her statements: a locked bedroom door, the window screen, what the children were doing before her husband left.
Dr. Mack believes those words show that Lindsay understood that the children were innocent and understood that the action, what she was about to do, was final. Final. I'm not so sure that that means wrong in her mind if she's psychotic. Maybe it's final because maybe she wanted it to be final. Go to God. You can't go to God if you're alive.
And then the words she allegedly said to each child: go to God. Go to God. The prosecution's expert said those words prove she understood the children were innocent. She understood the action was final. His conclusion was direct. She knew right from wrong. She retained the ability to follow the law.
Can she conform her conduct? And that is where I think the defense is going to lean very heavily on. If you only need a 2, don't blow the whole case because you're going for a 10, if that makes sense. And I was unimpressed with him, to be honest. And honestly, Ashley, I was watching some of that testimony, kind of pacing around in my computer screen, wanting to jump in the game because there was a lot of vulnerability there. I do not think the prosecutors.
But Murphy said the defense is going to lean on Massachusetts law, and that law is different. The question is not whether she understood right from wrong. The question is whether she could conform her conduct. That third prong changes everything, and the defense expert knew exactly how to aim at it. The paperwork already knew.
Any other
Different when you're standing in the well, right?
Yeah, that's right.
He also at one point used the language saying that she was unable to appreciate that her actions were wrong, which again sounded like he was quoting law to help, his hired attorney, the defense attorney, along in the case. So does the defense attorney then take his words and re-quote them to the jury, or does that start to sound like you're protesting too much?
Murphy also said the defense attorney got away with murder on that. Excuse the pun. Having an expert instruct the jury as to law is totally improper. You cannot do that. And the prosecution should have been out of their chairs. They were not. That single failure may end up shaping the verdict.
And look, I'm going to call the shot here. I think this jury is going to go with the defense. I think that's what's ultimately going to happen.
Why do you think that? Because of the lawyering?
No, I think that first and foremost, it's very, the fact that postpartum, it's important to remember there's postpartum depression and there's postpartum psychosis. Those are different things.
Very.
And
huge,
postpartum depression is very, very common.
Murphy made a prediction. He thinks this jury is going to go with the defense. He said it is not about the lawyering. It is about the facts and Massachusetts law. It is almost as if that law was written for the facts of the Lindsay Clancy case. That is not an emotional statement. It is a legal one.
Him, although the ending here, where she is found under Massachusetts law, and I think I think the jury is going to find for the defense. Just my guess, and I think that's I can't on this one. Like
he said, he understands why a jury would reach that conclusion, but the process matters, the rules matter, and when a hired expert steps over the line and starts telling a jury what the law requires, someone has to say something. In this courtroom, no one did. The paperwork already knew.
Still learn new things. I think that's something we can apply to life. You always learn something new every day, even when you don't think you can. I'm really curious about how long you think this jury is going to deliberate once the closings happen, and they're scheduled for next week. I'm recording this on Saturday, August the 22nd. But I mean, to be a fly on the wall, right? Follow behind them as they walk in and the door closes, and it's just them.
The jury now has to decide which expert to believe. They have to decide whether a lack of documented psychotic history proves the voices never existed, or whether she concealed the most disturbing parts of her illness. They will do it alone in that room, with no judge, no clerk, no bailiff. Just 12 people and the words that were allowed to stand.
Is it possible they might hang and be so split they won't have a decision? So again, Pop them in the comments. I love hearing where you guys stand on this. You know, pretty much where I stand. I usually try to be open to both sides, but in certain cases, I definitely feel a certain way. And in this one, I feel a little like Matt. Like, I think this is going to be a case that goes to Lindsay Clancy, not the prosecutors. But you never know. I thought that about it.
The public record is still being written. The trial transcripts and court filings are available. Go read the exact words the defense expert used when he was on the stand. Then ask yourself one question. Was that a diagnosis, or was that a jury instruction delivered by the wrong person? Put your answer in the comments.